It's fugitive Australian journalist Shane Dowling from the website kangaroocourtofaustralia.com. Now, I've just published an article on my website on Thursday, the 11th of May, 2023, and it's titled Samantha Maiden uses frivolous rumour to slut-shame Brittany Higgins on the orders of Rupert Murdoch to protect the Liberal Party. Now, I'll just read you out the first couple of paragraphs. Rupert Murdoch's propaganda, Samantha Maiden, published an article on Tuesday, the 9th of the 5th, 23, in a deliberate, calculated attempt to slut-shame Brittany Higgins. Ms Higgins has a good chance to be called to give evidence at the ACT inquiry into the police cover-up attempt of her alleged rape, which Murdoch and Maiden would know, and they were clearly attempting to intimidate and/or harass Higgins, not to give evidence by slut-shaming her. Now, I won't say too much more about my article. Make sure you go to my website, Kangaroo Court of Australia, and read that article, have further information. But the bottom line is that Samantha Maiden made up total and utter lies, basing a story on an unverified rumour. That's right, an unverified rumour about Brittany Higgins' sex life is enough to slut-shame her. Well, it's total and utter crap, and it's absolutely scandalous. It was raised in the inquiry on Wednesday, the 10th of May, 2023, and the article was basically taken down pretty quick because they were in big trouble. Not only was it embarrassing for Brittany Higgins, but it was defamatory of her and quite possibly in contempt of the inquiry. Now, I'm just going to play a quick video of Shane Drumgold, SC. He's Director of Public Prosecution for the ACT, and it's his complaint that ultimately led to the inquiry into the allegations of police corruption trying to cover up the Bruce Lemon alleged rape. In this video, he says, was this a government minister exerting pressure through the federal AFP commissioner onto ACT policing to make the matter go away? Well, I won't say more than that. You can listen to Shane Drumgold yourself.
Some of the questions in my mind, hypothetically, were, was this at the time a government minister exerting pressure through the federal commissioner onto ACT policing to make a matter go away?
Why would you think that?
As I've covered there, I'm looking at the circumstantial strands. I'm looking at a enthusiastic engagement by a senator, and I'm looking at unprecedented pressure being placed on me, an unprecedented passion that a number of police held that this matter shouldn't proceed, and a number of other factors, including them injecting themselves into a suggestion that I should outsource the decision to in relation to a retrial. There were just enough circumstantial strands in my mind to at least justify investigation into them.
Now, after the media storm hit Wednesday morning at the inquiry, there was debate about what to do. Initially, there was a suppression order put on it, and ultimately it was lifted, that suppression order. But early in the morning, Mark Tedeschi, KC, raised the issue. He's there representing Shane Drumgold, but he didn't raise it as part of his defence of Shane Drumgold. He raised it as a officer of the court, so to speak. And once Samantha Maiden wrote her story, other media jumped on the bandwagon, and Channel 7 did, and that's what Mark Tedeschi addressed, because he'd seen it on the nightly news the night before on Channel 7, and it wasn't very impressive. So let's hear what Mark Tedeschi has to say.
But it would be impossible to understand what was being discussed if the significance, the content of those documents wasn't understood. Your concern is that the contents of those documents having been disclosed, they're being misused by the publication of their contents as though those contents might be true. And
the way it was broadcast, Chairman, it was at a time when Detective Chief Inspector Borman's image was on screen.
Yes.
And it was a reference to police inquiry. So it was portrayed as being that this is something that the police had found out.
Yes.
Whereas the true source of the information was office scuttlebutt.
Yes.
And I can take you, Chairman, to that information.
You don't need to persuade me.
The vice is, firstly, it would be extremely distressing to Ms Higgins.
Yes.
Secondly, it would tend to discourage any future complainants from bringing complaints of sexual misconduct or assault to the attention of the police. It's precisely the reason why the criminal justice system of every jurisdiction in Australia has sought to prevent such information being part of a criminal trial. And it exemplifies the very prejudicial stereotyping that
yes, I understand that. What is it you want me to do?
Well, firstly, we would suggest that the precise material, the actual wording on that document should be suppressed or redacted in some way. We would ask you, Chairman, for your information officer or some other appropriate officer to notify the media that it has been either redacted or the subject of a non-publication order. And we would ask you to make some suitable comments about the fact that on the first day, you asked the media to report this case with responsibility and sympathy. The reference on Channel 7 that I saw was the exact opposite of that.
Well, I wasn't aware of Channel 7. I was aware of other media stories of that kind, and I was going to say something about it, not this morning, but later in the day. So I think what I'll do is make a non-publication direction in relation to those documents. I'll do that in a moment. So what I'll need to do is to have somebody in one of counsel assisting identify those particular review documents so that I can refer to them specifically in a non-publication direction.
On Wednesday, the 10th of May, the chairperson had further discussion on the issue with the relevant barristers in the quasi courtroom, I suppose. And he adjourned the matter for a short period, and then he had this to say.
This morning, Mr. Tedeschi, KC, brought my attention to some media stories in which journalists have picked up short statements in the documents, statements that are defamatory of Ms. Brittany Higgins, that are scandalous, which could never have surfaced at the trial, and which have been made available to me by me only as a small mosaic piece of the whole of the evidence for the sole purpose that I have explained. To give prominence to a scandalous, unjustified, defamatory, and prurient isolated statement on the pretense that it has some independent importance for an understanding of the issue that I have referred to is not just low journalism. It does not represent a fair report of the proceedings. It is actionable. It may constitute a contempt of this inquiry because it involves an abuse of the access that I have allowed to the evidence before me. It is also a mean and cruel thing to do to somebody. I know that there have been similar repugnant publications on social media by individuals. These are also actionable, and it would not be hard to track down who has posted this kind of material. In the course of many dealings with experienced Australian mainstream journalists as part of my work over some decades, I have learned to trust their ethics and their professionalism, and I have not once been disappointed. My trust has been damaged today. I'm not prepared to conduct this inquiry in a way that causes avoidable harm. Two young people, Ms. Higgins and Mr. Lerman, are at the center of this matter. Their lives have been irrevocably changed in the course of the last few years. Each of them now has a burden to bear. At least they'll have to accept that they will be the subject of public discussion and debate for a long time. But they don't have to tolerate being defamed or maligned. I've been urged to suppress some of the evidence before me to avoid this. I've thought about whether I should conduct all future hearings in private. I have thought about whether it would be better, at least, to restrict the free engagement that my staff has had with journalists until now. I've thought about whether I should do any of these things. Pursuit of the truth in the public eye is very important, but the truth can cost too much, and the cost will be borne by people who do not deserve to bear it. The simplest and most effective thing for me to do is to cease holding public hearings and to hear the rest of the oral evidence in private. That would be easier and it would be cheaper than anything else. It will instantly solve for the future the problem that I am addressing. I'm loath to take such a step that would change the character. Ms. Christanthu and Mr. Quill, who appeared for several Ms. Christanthu, who appears today for Ms. Wilkinson, but who has made submissions to assist me, and not on behalf of her client, and Mr. Quill, who appeared by leave today for 5 media organizations, emphasized to me that the public nature of the inquiry is too important to be let go. Mr. Quill reminded me that the importance of the publicity attached to these hearings is emphasized by the statute in subsection 4, which requires me, before making a direction for that hearings be private under subsection 3, to take as the basis for my consideration of the issue the principle that it's desirable that hearings be in public and that evidence given before or the contents of documents lodged with or received in evidence by the board should be made available to the public and all people present at the hearing. The subsection provides that I must pay any due regard to any reasons given to the board why the hearing should be held in private or why publication or disclosure of the evidence should be prohibited or restricted. It is well for me to remind myself that that is the statutory foundation upon which I should proceed. In substance, Mr. Quill and Ms. Christanthu submitted that I should not balk at the first sign of trouble. I take it that this is particularly so since nobody has asked me to continue to conduct the inquiry in private. I have decided, with some trepidation, and on account of the statements made by me to me by Mr. Quill about the importance to which his clients will attach to the my concern that I've expressed today, I've decided that I will not cease conducting hearings in public. I've been made very sensitive to the damage that can be done, and it will now take very little more for me to start going about my work in a different way. As to the documents that have been used in this harmful way, Ms. Christanthu submitted correctly that it would be impossible to formulate a direction that would be effective to suppress or even substantially suppress republication of the offending material. And she has demonstrated to my satisfaction that the direction that I made this morning would not have such an effect. I therefore vacate it. In the result, I'll do nothing today except ask the media companies that have published this loathsome material to do all that is possible to remove it from the public eye.
Now, this corrupt media clearly being coached by the police. The police are under huge pressure. If it's found to be true that they tried to cover up the alleged rape, well, they could be facing jail time. There's obviously politicians and others involved as well who would be very, very worried. And they're clearly coaching the media with lies, and those media people are reporting the lies. Rupert Murdoch himself, well, he knows the Liberal Party are a cash cow for him. They do him favours when they're in power. E.g., they've forced Google and Facebook to pay him millions of dollars. JobKeeper, he definitely made hundreds of millions of dollars from that. I know Seven West Media got 47 million. That's a fact that was reported. And Rupert Murdoch's business interests in Australia, their News Corp, etc., obviously 5 to 10 times bigger than Seven West Media. So if Seven West Media got 47 million, it's fairly obvious that News Corp got 200 million to 400 million, somewhere around that mark. And he got that free of charge from the Liberal Party. So he looks after his cash cow, the Liberal Party. And if it's found the police did cover up, that obviously reflects poorly on the Liberal Party and probably involves some of them. Well, I mean, I have no doubt it does. So he's trying to protect them, and he's unloading on Brittany Higgins because she's obviously her evidence, whether it's been written or in person, I'm not too sure. But I'm pretty sure she would be giving evidence of some sort. Well, that could be costly for him, so he's attacking her. He has his propagandist attack dogs like Samantha Maiden attacking Brittany Higgins with made-up lies. And I'll be following up with the inquiry, so make sure you hit the like and subscribe button on my YouTube channel. Kangaroo Court of Australia's independent media. I publish a website, YouTube channel, Facebook page and Twitter account. and I'm reliant on donations to keep on publishing. So please support my Patreon account. You can donate any amount, $3, $5, $10, $15, $20, $50, whatever suits your budget. It all helps out. Currently sitting on 224 supporters donating $1,315 a month. The ultimate target is to get to 1,000 supporters, but if I can get to 500 supporters in the next few months, that'd be great. And please share this video on Facebook and Twitter, etc. Thank you for your time and have a good day.